Hello everyone, and welcome to Black, Female, Queer, and Legal. And today I will be bringing you guys the Fourth Amendment, which is search and seizure. And for those who don't know me, I'm Tiara Grayson, aka TT. So stay tuned. I just want to let you guys know that you will see me look over to my left quite a bit. I'm referencing off of my laptop. Yeah, so let's get into it. So what exactly is the Fourth Amendment? And well, let's get into it. So the Fourth Amendment is the right of people to be secure in their persons, houses, purpose, and effects against unreasonable searches and seizures. Shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So I just want you guys to know that there's some stipulations with the amendments and our rights. We have the constitutional rights to be secure within our persons. However, this only applies to governmental actors. So, for instance, your landlord. If you're living in a place where you rent, and say, for instance, your landlord decided to come by and, I don't know, look at, his property or whatever. And for, some crazy chance, he finds, I don't know, like some drugs or something out on your you're out and about, just freely out and open while he came in. It could be on a counter, table, doesn't matter. But it's out, visible for your landlord to see. And, they decide, well, I don't want drugs in my property, so I want you evicted. You gotta go. So I'm gonna give you 30 days to go. You got to go. And they legally can do that because they're not a governmental actor. They're not a judge. They're not a police officer. It's not firefighter. It's not a corrections officer. It's not a dog catcher, you know what I'm saying? This only applies to government actors, More than likely, if you had to take a civil service exam, if your job required you to take a civil service exam, you more than likely, 9 times out of 10, is a government worker. So this applies to you. You can't just be walking up in people's houses. You know what I'm saying? You can't just be walking all willy-nilly up in people's houses. But this applies to, only government actors, regular people, myself. You know what I'm saying? Secondly, this only applies when there is a legitimate expectation of privacy. A legitimate expectation of privacy. There are 2 tests, so shall I say, to determine if there was a legitimate expectation of privacy. Test number 1. Did the person subjectively expect the matter to be private? Did that person expect privacy? That's the first one. The second one, is this reason objectively reasonable? So is there reason for saying like, hey, I got privacy. Well, why do you think you have privacy? Well, here's my reason. Is that reason objectively reasonable? Can 5, 6, 10 other people look at this or hear this reason and say, this is reasonable objectively? Like, here's an example. Okay, say for instance, I committed a crime. We'll say I committed arson. I purposely burnt someone's house down. I intended to burn somebody's house down with some gas or whatever, right? Excuse me. And I am on the bus, on the public transportation. And, there's a couple of other people on the bus with me. I ain't paying them no mind. I'm on my own little world. I'm motherfucking on my cell phone, calling my wife, and I'm like, babe. So, Joe just pissed me off, and I just went to this nigga's house and burnt that junk down. The whole house down, burnt. Ain't nothing left but smoke. It's gone. Nothing left. And then someone overhears the conversation. It could be anybody. It could be a police officer who decided to ride the bus today. Or it could have been a random, just a random civilian, just a random person like me. We're not governmental actors. This is a random person sitting on the bus, taking the bus. They hear me tell my wife that I motherfucking burnt Joe's house down, nothing left but smoke. Whether it's a police officer or a regular person, if it's a police officer, the police officer comes up to me, ma'am, I just heard you committed a crime. I'm going to take you in. You're under arrest. Or, for instance, an innocent bystander hears the conversation. They call the cops and they're like, hey, this woman on the bus talking about she burnt somebody's house down. The police shows up and they're like, ma'am, we got to take you in for questioning. Why? We need to search you. All right. In those two instances, I don't have a legitimate expectation of privacy, and it's based on my setting. Why don't I have a legitimate expectation of privacy? It's because I am on a public transportation. I'm on a bus. This bus don't just, it ain't my bus. I'm not the owner of the bus. I don't drive this bus around just for my personal use. This bus is intended to pick up all, any and everybody in the world publicly. However, if I am in my house, and I'm going to have a whole other conversation. Now, I don't know my walls is thin. You know what I'm saying? I'm just talking. I'm like, babe, Joe pissed me off. This nigga was just at me. He called me, all types of stuff. Just flat out disrespect me. I couldn't take it. Burnt this whole house down. With his dog in there. And somebody hears the conversation and the police shows up. Guess the freak what? Those jokers can't come and they can't do squat. They cannot do squat. You know why? Because I have the legitimate expectation of privacy. I am in my house, talking on my phone in my house with my windows closed, my door closed. I'm not trying, this isn't a public, domain. This is my dwelling. So I have a legitimate expectation of privacy there because I'm holding a conversation in my house that is not open to the public. It's only open for me and whomever I allow. So, that way you got that out the way. Probable cause. So, for those who don't know what probable cause is, let me tell you what probable cause is. You ready? So, probable cause is the reasonable basis that a crime had occurred. Pretty much. But I'm going to give you the definition that I got wrote down. Probable cause is the reasonable basis for believing a crime may have been committed or when evidence of a crime is present in the place to be searched. So probable cause is the reasonable basis for believing a crime may have been committed. The reasonable basis for believing a crime has been committed. You see what I'm saying? So, let's back it up with some cases. In Draper V United States, 1959, the case that probable cause is the practical judgment in which one reasonably consider a crime has occurred. So, the objective motherfucking, ties into that a crime has occurred. You can't arrest somebody just because you feel like it. You know what I'm saying? You can't, a crime, you have to believe a crime has occurred in order to arrest somebody. And to search somebody, you have to believe not only that the crime occurred, but the evidence to that crime is wherever you think that it is so you can search. You know what I'm saying? Do you know what I'm saying? So, for example, I'm walking down the street. Nothing's happening, just regularly. Walking down the street leisurely, minding my business. And a police officer comes up to me and he's like, hey, I want to search your pockets. Or, can I search your pockets? I say no. They're like, well, come here. I want to search them anyways. And then they start searching me. Or the police officer comes up to me and say, hey, you're under arrest. And I'm like, for what? And then they're like, because I want to. They can't do that. They can't do that. You know what I'm saying? That's not. How are you going to convince somebody that that's reasonable? There's no. What are you arresting me for? Do you believe a crime has occurred? Is it reasonable to think that it was me? You know? What happened? Where we going? I need some information, officer. And then that's the situation where, you know, probable cause doesn't exist. They can't arrest nor search you. Now, in a instance where, here's this scenario. A crime has just occurred. A robbery occurred at this convenience store on the corner of East Main and, I don't know, we'll say Paul Street. East Main and Paul Street. I just so happened to run right past the corner of East Main and Paul Street where, you know, the building was that the crime had occurred. I'm running frantically because I'm like, man, I got to get to work. I'm already running late, had to tend to my dogs and everything. I'm running late and I got to catch the bus. The bus is like right there and I'm about to be late. So I'm running. I want to catch the bus so I can get to work. So, you know, I don't miss out on that paycheck. Police comes up to me and they're like, hey, ma'am, can I talk to you for a minute? Ma'am, where are you going? You know, what's your name? Where are you headed? Da. In that instance, the police legally can stop me and, you know, ask me some questions because probable cause occurs. Where it occurs is the fact that a crime had just occurred in this one area. The police are trying to gather all information they can pertaining to that one crime. Then they see this random person that just so happened to be booking it down the street, like booking it, you know what I'm saying? And they're like, what the freak? We just had a crime. We got caution tape all out, you know, don't cross, you know. Like, it's serious out here. We got a robbery. And this person running around all frantically, like, is she the robber? Let's go see. And then they come and then they start asking questions. Police can do that. They can do that. Governmental actors can do that. Because the probable cause is in the fact that it's suspicious for me to be running to them. To me, it's not suspicious, but to them, it's suspicious because they are casing a crime. They're you know, trying to gather as much information as they can at this crime scene. And then you got some random black chick that just ran by. You know, looking all crazy. I look crazy because I'm full-fledged running. You know, the situation. There's a crime that occurred in this area. You're running, looking suspicious in that same area where the police are at investigating. So they legally can, you know, ask you some questions, try to eliminate, or confirm or eliminate the fact that you are, cannot be, you know, the robber of this crime. And then, let's go further into it. For those who don't know what support by oath of affirmation is, it's pretty much self-explanatory in a sense. But it basically means that a warrant must be approved and signed by a non-involved magistrate or judge. In the case Coolidge V Hampshire in 1971, the Supreme Court held that a warrant must be issued by a neutral and detached judge capable of determining whether probable cause exists. So the judge pretty much has to look at the warrant and say, okay, probable cause exists. You know, I'm not, you know, like I'm a judge in a whole different county. Like for instance, the crime could have occurred. You know, they want the warrant, the house that they want to search, where is in Monroe County, and say for instance, the police officer goes over to, I guess like the next closest county, we'll say, I don't know, Livingston. They go to Livingston County and get a judge and magistrate to sign off on it. The judge looks at it and he's like, okay, probable cause exists, everything is here, I'm gonna sign it. That's all that's saying, is that the judge cannot be attached to the situation, because then it becomes, you know, bias and it's a little tampered with. So that's how they keep clarity on that. Also, a search warrant must state the specific place to be searched and the specific items to be seized. It is improper and a violation if the warrant, if it lacks accurate information. And this was decided in the case Gro V Ramirez in 2004, which pretty much means that in order for a search warrant to be valid, a police officer has to include on the search warrant what the items are that they intend to seize, where is it located, if it's located in the house, where in the house, what bedroom. Like, you can't just search all the bedrooms. I mean, if you're trying to find a stolen car, it will make sense to search someone's home garage. You know what I'm saying? It don't make no sense to come into somebody's home and you motherfucking raid in their refrigerator. You can't put a car in the refrigerator. You know what I'm saying? So that's all it's saying, is that this search warrant has to say what items are being seized, what are you looking for, what are you intending to take, and where do you think this is at? Where is it? Specifically, where is it? Don't tell me the house. I want to know where in the house is it, because I don't want you searching the whole house. You have to search the specific area that is reasonable to this item. Like I said, you're not going to search a refrigerator looking for a stolen car unless it's a toy. A search warrant must also be filed in good faith by a law enforcement officer. And the good faith exception is based on the exclusionary rule, which was decided in the case United States v. Leon, 1984. So what this pretty much means is that, okay, so good faith is pretty much meaning honesty, fairness. So, the police officer filed this search warrant being honest and fair and full. They didn't file this search warrant with the expectations of literally just searching. Like, they don't even know, like, they're just like, oh, we think that this person has some evidence of a crime. We don't know exactly what it is, where it's at, but here's our search warrant. No, that's not good faith. That's crooked. You're crooked. No, you need good faith. Good faith is that you submitted that search warrant in full belief that the person that you are trying to seize or the items that you are trying to seize are the correct, it's valid. It pertains to the crime that occurred. Not only that, but you have to show that you had no negative intentions. You're not coming in as dirty. You know what I'm saying? You really thought that, you really believe that this is, this is the evidence, this is the person, this is where it's at. There's no doubt, like, this is what you believe. You also believe that when you walk out of there, when the judge signed it was judge that was supposed to be. The judge signed with full, expectation that your warrant was completed. So if a judge signed off on a warrant that was improperly done, and you thought that it was, it stands. Because that second safety net, which is the judge, because before your search warrant goes out there, you put it together. It's like, okay, I got it together. Now it has to be approved by a judge. Take it before the judge. Judge look it over. Okay, this is right, and then they sign off on it. A judge sign off on a search warrant that you filled out improperly. You went on good faith that judge knew what they were doing. That judge confirmed that probable cause exists before they put their name. They signed their John Hancock on it. You know what I'm saying? So, yeah. And like I said, this was decided in the case United States v. Leon. And for the exclusionary rule, because I know I brought that up and I haven't told you guys exactly what that is. The exclusionary rule is a law that prohibits the use of illegally obtained evidence in criminal court. So it pretty much means that, all right, let's get in this. So say, for instance, the police officer comes up to you. Look, they're like, you look suspicious. You look suspect. Let me check you. Sir, ma'am, can I search you? No, you may not, sir. No, you may not, ma'am. And they're like, okay, well, I'm a police officer and I can do as a please, so I'm gonna search you anyways. And they go to stick their little dirty paws in your pockets and they fill it around, and then voila, they done pulled out a mother freaking kilo of cocaine, that you was hiding in your mother freaking North Face thick all winter jacket because you live in upstate New York like me where the weather is like -2 degrees all the time. Exaggerations, but still. So now they got this drug and they're like, yes, you're under arrest. We're going to lock you up because you got 1 kilo of cocaine in your coat that we found. So, all right. You think so, Mr. Officer? Bet. Let's get on to the court. Let's get to the court, sir. Let's get on in there. So then you go through the process before you even get to the court, before you even get to the trial. You know, they're looking at everything. Was the evidence confiscated? You know, was it seized in the fashion that it was supposed to be, etc. And then it comes out. Well, the police officer asked if they could search me. I told them no. And they said, well, I'm a police officer, I can search you anyways. And they took it upon themselves and put their little greasy paws in my motherfucking pockets and started raiding my motherfucking North Face jacket, exposing me to this frigid cold out here, and pulled out the kilo of motherfucking cocaine. I told them they couldn't, I didn't want them to search me, but they searched me anyways. I wasn't doing nothing. I was just walking down the street. I wasn't a part of no crime, no nothing. So, the judge will say, you know what? You're right. You know what we're going to do? We're going to make this inadmissible in the court. We're going to make this inadmissible. This cannot be used against you. You know why? Because this motherfreaking kilo of cocaine was seized illegally. And that's what the exclusionary rule says. Decided in the court case, United States v. Leon, 1984, it states that the exclusionary rule is a law that prohibits the use of illegally obtained evidence in criminal court. You can't use it. If police officers, if government actors illegally obtain evidence in your situation, they don't have probable cause, you know, they didn't get a search warrant to search you or any other matter, guess what? They didn't get that judge and magistrate to sign off on a search warrant. Guess what? They couldn't prove the probable cause. Guess what? Guess what? It's not admissible in court. They can't use that against you. So now that kilo of cocaine has to get thrown out. They don't got nothing in the case to hold you. And that's all they really want to have. So stay tuned for the next video. We'll be discussing in the next video, part 2, stop and frisk. Stay tuned.